Hi guys, and welcome to my channel. My name is Diana Romanovska. I am a certified family law specialist practicing divorce in the Bay Area, California. Today I would like to talk about what you need to watch out before sponsoring an immigrant spouse when you're getting married. And first thing is to consider that when you marry someone to get them a green card, you're in love, you're signing an affidavit of support for 10 years. It's called I-864 form that states that you are obligated to pay annual income not less than 125% for 10 years over federal poverty line during which affidavit is enforceable. So it depends on what year it's going to be, 125% over federal poverty line. The reason I'm talking about this case because it happened that case of appeal, Kumar case, California case of appeal, decided against a lower court, superior court judge who ordered, there was a case where, Kumar case, where wife asked for spousal support and the judge said no, because you're not going to get spousal support based on affidavit of support because you need to work, you need to make money, and I'm terminating court jurisdiction. And Court of Appeals said no, you're not allowed to terminate court jurisdiction because affidavit of support is an enforceable contract where the sponsor spouse, submits himself or herself into state's jurisdiction. And so the court has to enforce that contract, which means the court is technically not allowed, even in a short-term marriage. As you know, we can terminate spousal support half of the length of the marriage, approximately at that time. Done, let's say marriage is 1 year long, the court could terminate it after 6 months. Once everything is resolved, then it's no longer temporary spousal support, or not, it doesn't matter. The court has the power and authority to terminate jurisdiction. This case just mind-baffling because it contradicts, Court of Appeal decided something that contradicts the basic principle of family law. And it said, the Court of Appeal stated that the spouse, the sponsoring spouse, has to pay 10 years of over 125% of federal poverty guideline, unless, so doesn't have to pay if the sponsor spouse dies, the sponsored spouse dies, or the sponsored spouse receives citizenship or is credited 40 qualifying quarters of work. And so the sponsored spouse, the spouse who gets the money, doesn't get away. I mean, the spouse has to pay, and the sponsored spouse doesn't have to mitigate the damage by going and find a job. I mean, this is so basically you have this contract that has these exceptions that do not apply for family law. So I strongly disagree with this decision. However, it's a decision that we gotta live with, and so the family court still has the jurisdiction to say, well, you have to look for work, even though it's not an exception, which means I cannot terminate support. I cannot say no support at all. I have to respect this contract. However, I'm still going to say you have to look for a job. I can even impute, as a court, I can even impute minimum wage to the spouse if they have a green card and if they have an ability to work, which I would do now as a judge after this case, because it just doesn't make any sense to say that the spouse who is receiving, who got sponsored, doesn't have to live by family law standards. So anyway, so that's it's going to be interesting to see if this contract, affidavit of support, is enforceable when the spouse who sponsored the other spouse was defrauded when someone married the other spouse just to get a green card and never consummated the marriage, or some other annulment reasons applied. So it would be interesting to see how family courts are going to decide whether during the process, until it's proven that it's annulment, if the spouse has to pay support. And if so, if annulment is granted, does the sponsored spouse has to repay back the support he or she received during this temporary time? So there is also a common misconception that if a spouse who sponsoring spouse has to pay this 125% for 10 years over federal poverty line, that the sponsoring sponsor, the other spouse, is entitled to a buyout in that amount. I would never suggest to a client to settle a case and say, pay that spouse 10 years in advance, because this agreement could be also circumvented if the spouse who received support already, that buyout amount, fell into government support. The government doesn't care what has happened. They just want to avoid paying social security, or not social security, welfare. So they would go after the spouse who paid that buyout, and the spouse who paid the buyout will try to get reimbursed because, wait a second, I paid you buyout so you don't go and ask government for support, but now the government is asking. It's like dealing with IRS, right? If you file taxes jointly, IRS doesn't care what agreements you have. They just want the money from one of you, right? And it's going to be the spouse who has the money, and then try to get it back from your sponsored spouse. So I would leave it to the court to decide on this, how much support is owed, whether the sponsored spouse is imputed income, and I would not offer buyout. So I hope that was helpful. If you liked it, click like, subscribe, and see you in my next consultation. Bye.